everyone, and welcome. My name's Elizabeth Kronk-Warner, and I have the privilege of being the Dean at the S.J. Quinney College of Law, which allows me the opportunity to participate in amazing events like the one you're about to hear. My pronouns are she and hers, and as I like to do anytime that we're gathering, I do want to start off by acknowledging that the land that we are currently on, which is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that we have between many indigenous peoples and their traditional homelands, and we respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. And so it seems appropriate that we should be gathering here today for this important community outreach activity. And I have the absolute privilege of introducing just a gem of a human being and a gift to the University of Utah. She also happens to be my colleague, so I'm very fortunate. And that is Professor Erica George, who's the Samuel D. Thurman Professor of Law here at the S.J. Quinney College of Law. She also holds an appointment as the director of the Tanner Humanities Center. She teaches in the areas of constitutional law, international human rights law, international environmental law, and seminars on corporate citizenship and sustainability. She earned her BA with honors from the University of Chicago and her JD from Harvard Law School, where she served as articles editor of the Harvard Civil Rights and Civil Liberties Law Review, as well as classmate of a certain famous somebody who's currently nominated to the Supreme Court. Her research explores the responsibilities of multinational corporations to respect international human rights and efforts to hold corporations accountable for alleged rights violations. She's a member of numerous boards and organizations. She's testified between international human rights treaty bodies, foreign governments, and has briefed international media on just about everything you can think of. She's so talented and she's such an amazing oralist that she's been sought out by the likes of the BBC, The Economist, NBC News, CNN, and the Christian Science Monitor. She's going to be introducing our speaker today and moderating the questions and answers. And so with that, I will turn it over to the one, the only, Professor George.
Thank you. Wow, thank you for that extraordinarily kind introduction. I am grateful to have such a gracious dean. Thank you, Dean Kronk-Warner. And I have the privilege of introducing tonight, and our speaker. So we are gathered here for the Leary Lecture. The Leary Lecture is named in honor of William H. Leary, the College of Law's dean from 1915 to 1951, which sounds extraordinary. Dean Leary was renowned for his intellectual rigor and his love of teaching. We honor his legacy each year by inviting educators to share their experiences and to address us on topics of their choice and contemporary concern. Past Leary lecturers have included Owen Fiss, Patricia Williams, Eugene Vocal, Kathleen Sullivan, Cass Sunstein, and Kenji Yoshino in past years. The people we select really embody the commitment to education and intellectual rigor and love of teaching that Dean Leary did. And tonight we could not be more fortunate and we couldn't have a more appropriate speaker to deliver the Leary Lecture. Tonight we welcome Gabriel Jack Chen. He is the Edward R. L. Barrett Jr. Chair of Law, the Martin Luther King Professor of Law, and Director of Clinical Education at the University of California, Davis. His scholarship has appeared in the Pennsylvania Law Review, the University of California, Los Angeles Law Review, the Cornell Law Review, and the Harvard Civil Rights, Civil Liberties Law Review, where I was an editor as a student, as well as Yale, Duke, and Georgetown law journals. Recently, the U.S. Supreme Court has cited his work on collateral consequences of criminal convictions in Chavez versus the United States, in which the court called his Cornell Law Review article the principal scholarly article on the subject. And in Padilla versus Kentucky, the court agreed with his contention that the Sixth Amendment required defense counsel to advise clients about potential deportation consequences of guilty pleas. Justice Sotomayor has cited his Penn Law Review article in her dissent in Utah versus Strelov. In addition to teaching criminal law, criminal procedure, and immigration, he serves as the director of clinical legal education. I think this is vitally important because he brings the classroom to the world. He works with his students on professional projects. He's got 2 interesting projects right now I'd like to highlight. His efforts with students have been efforts to repeal Jim Crow laws that are still on the books. This has included a successful petition to the Ohio legislature to ratify the 14th Amendment. Yes, they hadn't. 136 years after the state disapproved it during the ratification process. He and his students have also achieved the repeal of anti-Asian alien land laws, which were on the books in Kansas, New Mexico, and Wyoming. For his work, A magazine called him one of the 25 most notable Asian Americans in America. In addition to his classes that have the practical component, he has tried felony cases, he's argued criminal appeals with his students, and he's done some really important project work. He earned his bachelor's from Wesleyan University, his law degree from University of Michigan, as my dean did, and an LLM from Yale. He clerked for the U.S. District Courts, Judge Richard Match in Denver, and he practiced law with a large corporate law firm, Skadden and Arps, some of you may have heard of. He was at the Legal Aid Society of New York, and he taught in Arizona, Cincinnati, NYU, Western New England law schools before joining UC Davis, where he has done tremendous work. 2 projects of note I'd like to highlight is the Hong Yin Chang project. Professor Chen has successfully obtained posthumous admission to the bar for this Asian American lawyer, the first Chinese American lawyer in the United States. He represented UC Davis, California Supreme Court Clinic, and the project has been honored by the APA Bar Association of Los Angeles. The story was covered in NPR's Morning Edition, Chinese Immigrants Denied Law License, and 1890 Gets One. And then his Chinese restaurant project. Professor Chen, along with a colleague, identified a previously unknown effort to eliminate Chinese restaurants from the United States using legal techniques from discriminatory zoning to prohibitions of people working in various types of restaurants. Their paper, The War Against Chinese Restaurants, appeared in the Duke Law Journal, and his research for this Chinese restaurant project was reported in the New York Times, by NPR, the Chicago Tribune, and other media outlets. So what I so appreciate about Professor Chen's work is that he takes concepts that we teach in the classroom, he puts them in the real world, explains those impacts, and actually drives change. So thank you for all that you do, and we look forward to hearing from you. Join me in thanking Professor Chen. Welcome.
Thank you, Dean Warner. Thank you, Professor George, for this wonderful welcome and the opportunity to speak in the lecture series named after such a distinguished member of your community. I don't get to Salt Lake as often as I would like, but every time I'm here, I find it so beautiful and warm and welcoming. I have not been here since the old building was around, and I think this one's better. I'm going to talk today about Asian Americans in the law and what it might have to say about our contemporary situation. And my sense is that right now, there's a kind of reckoning, a kind of consideration, attention to the status of Asian Americans in the United States that really has not existed, perhaps since the Asian exclusion laws were repealed in 1965. And I'm going to talk more about those later. But I'm thinking of 3 things in the contemporary scene that really put Asian Americans in the forefront. The first is anti-Asian violence, and this violence ranges from street harassment of people who are perceived to be Chinese, but might be Japanese, Korean, Puerto Rican, are the reports of people who've been harassed on the street with complaints about the China virus and the Wuhan flu. I understand that there were 800 reports in Utah in the last couple of years of this sort of thing. And that's one form of anti-Asian violence, and it extends to murder, of the killing of 8 Asian American spa workers and others in Atlanta. The second thing I'm thinking of is the China Initiative. And the China Initiative was a project of the Department of Justice that sought out scholars and scientists who were thought to be involved in illegal technology transfer to China. And there's nothing wrong with prosecuting economic espionage, but an unusual number of those prosecutions were dropped on the eve of trial, not because of a plea agreement, not because of some successful defense motion to get rid of the case, but because when the Department of Justice took a closer look at the facts, they realized there was no case there. I'm thinking, for example, of the Sherry Chen case. Sherry Chen was a hydrologist for the National Weather Service, and she was indicted for felonies for using somebody else's username and password to get into a sensitive computer. But it turns out that her boss had written down this username and password in a binder and put it in the room where the computer terminal was, and everybody in the office was instructed to use that username and password. And she also sent technical information to a Chinese official, but she had copied her boss on that, and it was public information. And so the week before trial, all the charges were dismissed. Oops, it was a mistake. But she's been trying to get her job back for 7 years, and that is ongoing. And she's not the only one who's had that kind of experience. The other thing that I'm thinking of is Penn law professor Amy Wax, who recently said on a conservative podcast, got a lot of publicity, that it would be better for the United States if there were fewer Asian immigrants for a variety of reasons. And, you know, Professor Wax doesn't just have opinions about Asians. She finds a lot of room for improvement among other minority groups as well. And there's been a lot of criticism of Amy Wax. But she certainly hasn't been canceled by the right. As I say, she's a professor at the University of Pennsylvania Law School. Asian Americans are the largest racial minority group at Penn. And I think she forgot the old business rule, don't deport the customers. But nevertheless, there she is. There's a lot that could be said about each of these things, including that there's been broad condemnation of the anti-Asian violence. Criticism of the China Initiative led to its nominal termination, at least in its current form. Of Amy Wax, I could say, well, if she thinks that Democrats are harmful to the United States, one wonders why she didn't propose excluding Democrats from immigration. Yeah. But I suppose it would be too controversial to exclude people because of their political beliefs. What I want to suggest is that each of these things in their own way supports the idea advanced by a couple of generations of Asian American scholars that Asians are regarded as the perpetual foreigner. There's an idea that they're not quite real Americans, no matter how many years, no matter how many generations they or their ancestors have been here. I don't mean to suggest that this is a universal view or a majority view, but it's a view that comes out occasionally, and I think it has now. I want to talk about the legal structure that was in place in the United States from 1790 to 1965, which embodied that view. There were a series of laws that were designed to keep Asians out of the United States. I call them the Asian Exclusion laws. And I want to talk about them because they're a building block of a larger hypothesis that I would like to submit for your consideration. And to oversimplify, I want to suggest that everything is about race, at least that race has been a central organizing feature of the United States. It's a hypothesis, which is falsifiable, and I am interested in hearing contrary evidence. But the hypothesis has the following sub-arguments. The first is that the United States today was pervasively shaped by race policy. The second is that segregation of non-whites was, for practical purposes, universal. There were, to be sure, in the United States, better and worse places. To be sure, there were white people, plenty of white people who were opposed to segregation. But even given those things, there was, I submit to you, no place in the United States where people of color were treated roughly equally in terms of political rights and education, employment, and housing until recent generations. That is to say, there was no place they could go where, if they had been smart enough and ambitious enough to go there, they would have enjoyed rough equality in those dimensions. The third proposal is that segregation systematically reserved the best opportunities for whites. And the fourth is that economic status is heritable across generations. So we should suspect, at least tentatively, that racial differences in economic status now are due to historical racism. As to the first point, I will say only two things. First, until 1921, immigration was not numerically limited in the United States. As many people who wanted to come could come. The exception was for Asians. As a result of the Asian exclusion policy, although half the world then and now was Asian, in this nation of immigrants, as late as 1960, about 0.5% of the US population was of Asian ancestry. Asian exclusion worked. The second thing that I will say about the first point is that the Constitution zealously respects rights of property, but a recent study out of Yale shows that of the 7 million square kilometers of land once held by tribal nations, 93.9% was taken away from them over the years. So I think we can imagine a United States that's very similar in many ways to the way it is now, except that it's 20 or 25% Asian, and 20 or 25% of the land is held by the Indian tribes. And what would that be like? I'm not going to say anything about points 3 and 4, and what I want to spend the bulk of my time on is how Asian exclusion is related to point 2. So there was, historically, a debate in slave times between abolitionist William Lloyd Garrison and formerly enslaved person Frederick Douglass. And William Lloyd Garrison said that the Constitution was an evil document because it protected slavery. He publicly burned it. And Frederick Douglass said, no, the Constitution contains the seeds of liberty, and we can use it to get rid of slavery. And so these represented two different views about the meaning of the Constitution, and whichever one of them was right, and maybe they were both partly right, even if we assume that the Constitution didn't embrace and protect slavery. It's unquestionably true that the framers of our country conceived of our country as a white nation. One of the first acts of the first Congress that was signed by some of your top framers, George Washington, John Adams, Thomas Jefferson, limited naturalization to free white persons. Now, the king's refusal to allow naturalization in the colonies was one of the complaints in the Declaration of Independence. So naturalization was something that was strongly desired, and it was important. So they dealt with it right away. Naturalization, the legal process for taking a non-citizen not born in the territory and making them a citizen after birth through some mechanism, was recognized as being an immigration law as well. The framers of the Constitution, the senators and representatives elected to the first Congress who passed this, understood that they were regulating immigration as well as citizenship. And the reason for that is in 1790, and today to a much lesser extent, there are some rights that are reserved to citizens. And one of those rights was the right to own land, because many states in 1790 had alien land laws that said you had to be a citizen. Agriculture is important now, it was more important then. So denying people the right to own land was, for practical purposes, a major discouragement to immigration for those who couldn't become a citizen. So technically, the borders were open. Supreme Court recognized this, but for practical purposes, as Justice Greer mentioned in the passenger cases, he didn't connect this to naturalization, but the 1790 law made it clear that the open borders were really most open on the basis of race. So in 1790, the big racial issues, I think, in the United States were not necessarily those having to do with Asians, but the situation of Africans and African Americans and of Native people. That is to say, I have no evidence that the 1790 Act was enacted with Asians in mind in particular, but they quickly were assimilated into the structure. One example that I think is important comes from Chief Justice Taney. Chief Justice Taney is famous or infamous for his decision in Dred Scott versus Sanford, which held that no person of African descent born here or otherwise could ever be a citizen by birth or naturalization. And the reason is the way they were thought of at the time of the framing. This was the first originalist decision, supposedly, and he infamously said that African Americans were thought of as so far inferior that they had no rights, which the white man was bound to respect. And one of the pieces of evidence that he used for that was the 1790 Naturalization Act, which he said showed that the white race was the citizen race. They were the ones who held the power. Well, 17 years before Dred Scott, he was doing a trial, as Supreme Court justices did then, on circuit in the District of Maryland. And he issued a decision in a case called United States versus Dow, where he dealt with some of the same issues that were at stake in Dred Scott, only in this case, they involved an Asian, in the racial category of the time, a Malay, which is to say now a Filipino. Lorenzo Dow, the defendant, was charged with murder of a white ship's captain. The witnesses against him were all, again, in the terminology of the day, mulattoes. They were people of African descent of some degree or another. Under the law at the time, a federal judge doing a trial applied state rules of evidence. And Chief Justice Taney understood the Maryland rules of evidence to provide that Negroes and mulattoes, free or slave, are not competent witnesses in any case wherein a Christian white person is concerned, but they are competent witnesses against all other persons. And so Lorenzo Dow didn't want these people of African descent to be able to testify against him, because then he would walk out the door for lack of evidence. Now, there was no question that Mr. Dow was a Christian, born in Manila, raised in the Christian faith. His parents were Christian, and the question was whether a Malay from the Philippines was white. And for several reasons, Chief Justice Taney said the answer was no. One reason is that he turned to the anthropologists who were engaged in the scientific categorization, now I think we would say scientific racism, of the day. And Malays were categorized as a separate race, not white. A big part of it, though, was his understanding of the political origins of the colony of Maryland and by implication of the United States. And he said, look, this was a colony founded by white people, for white people. They didn't want or desire anyone other than from the Christian nations of Europe, and if those people had come, they wouldn't have been welcome. So that's what white meant. They're not civilized. They're the only nations of the world that are entitled to be called civilized are the white Christian nations of Europe, and that's it. So he's not, according to Chief Justice Taney, a white person. He was convicted and sentenced to death, but he got pardoned back then, a lot more pardons. Dow got one. There was another important case along these lines in the antebellum era. This one also dealt with testimonial capacity, People versus Hall, in the California Supreme Court. And in this case, a white person was on trial, and the witnesses against him were Chinese. Now, I want you to understand what's at stake in the question of testimonial capacity. Because if you are a member of a gender or race that can't testify, then you can be victimized, raped, robbed, murdered, unless there are white witnesses around who are willing to testify against the assailant. And so being unable to testify is a big problem. It's a big problem. And that problem materialized in People versus Hall, white person. It had the same litigation desire as Lorenzo Dow, didn't want witnesses to come in against him. And there was a statute in California that said no black or mulatto person or Indian shall be allowed to give evidence in favor of or against a white man. And so how does a Chinese person fit into this? Because we could go look at the scientific authorities that were cited by Chief Justice Taney and were used in cases of this type, and you would think that a Chinese person is not black, mulatto, Indian, or white. But the California Supreme Court, 2-1, said we have to follow the policy of the statute. And the policy of the statute is some people, white people can testify against whites, and white people can testify against other people, but other people can't testify against whites, and we're going to read black, mulatto, or Indian to include Chinese. So this conviction has to be set aside. And there were policy reasons too. There was an extended discussion of the impassable barriers between Asians and whites, of the proverbial mendacity of Chinese, etc. And the court said we cannot contemplate that a member of such a group would have the right to swear away the life of a citizen, or because if they were white, they would possibly be allowed to vote, hold office, naturalize, etc., become a citizen and participate in the government. So legally, for Taney, for the California Supreme Court, in this pre-Civil War period, there's whites and there's non-whites. We go to the scientists to figure out who's who. We go to the history to figure out who's who, which side of the line a particular group is on. But Asians are readily accommodated into this structure. There's no fluidity, there's no ambiguity, there's no sort of difficulty. I'm aware of no cases in the pre-Civil War era where any reported decision says, hey, maybe Asians are white. That it's not within the contemplation of the scientists that these folks rely on for this purpose. So this is a long time ago. This is before the Civil War. During the Civil War and after the Civil War, there's a reconsideration of race in the United States. The Supreme Court, for a variety of reasons, gives us a clear and happy story. They say that the Reconstruction amendments and civil rights laws of that period were designed to eliminate racial discrimination from the law. It didn't happen for some reason, but that's the purpose. If we think about the role of Asians and their treatment during Reconstruction, it's impossible to conclude that the Supreme Court is right on this. Their view is not, in my view, related to the actual history of these laws. Now, in this period, there were a range of views. When you read the legislative history of the Reconstruction Amendments and the Civil Rights Acts that went along with them, you do see a number of people who argue for what we would recognize now as racial egalitarianism, non-discrimination, anti-racism. But you also see a large number of people who don't go along with that, and they ultimately are the winners in the Reconstruction debates. James Beck, a representative, said, "I will tell the gentleman what I would do with the Negro. I would protect him as a free man as I would protect our women and children or any other person who has not the capacity for exercising political rights. I would hold the Negro unfit for political rights as we do the Indian and the Chinaman for a great variety of reasons. His whole race has shown itself in all time unfit for self-government. The Caucasian race alone has developed that power, and that only under favorable circumstances by the growth of centuries and education up to the point which we think we've reached. Granting power to the freed people is an outrage upon the white race to which we belong, and one which the people of this country will never permit." So there was racism and anti-racism, and it cashed out in legislation in particular ways. I'll start with the Civil Rights Act of 1866. The Civil Rights Act of 1866, in its original version, offered a range of protections to inhabitants of the states. But Congress changed the protected class to citizens, and they did so to allow, specifically, there were votes, to allow the states to discriminate on the basis of race against non-citizens. There were states that prohibited certain non-whites from owning real property, and the Congress wanted to make sure that these laws would continue to be constitutional. So the Oregon Constitution of 1857, which I show you, prohibits Chinamen from holding real estate or mining claims. The Civil Rights Act of 1866 was designed to protect that. In 1870, there was another Civil Rights Act that extended some of the protections of the Civil Rights Act of 1866 to all persons. Again, this was done with the Chinese in mind. This was a pro-Chinese Civil Rights Act, but it deliberately excluded the right to own land. The rights that were extended to Chinese and other Asians were excluded. Here's what Senator Stewart, the sponsor of the bill, who voted in favor of the 14th and 15th Amendments, said about the Civil Rights Act of 1870. "Now, while I'm opposed to Asiatics being brought here and will join in any reasonable legislation to prevent anybody from bringing them, yet we have a treaty which allows them to come to this country. We have pledged the honor of the nation that they may come and shall be protected." So some federal protection of Chinese rights was necessary, but only up to a point. And even during Reconstruction, as slavery was abolished and the 14th Amendment guaranteed a bunch of rights, and the 15th Amendment, the idea of Chinese exclusion, of Asian exclusion, was floated, put on the table, and not shouted down. The 14th Amendment is mostly applicable to all persons. Privileges and immunities are guaranteed only to citizens, but all persons are protected from denial of life, liberty, or property without due process of law. All persons are guaranteed equal protection of the laws. The issue of whether Chinese born in the United States were citizens was litigated by the Department of Justice for many years. But in 1998, the Supreme Court, 7-2, held that Chinese people born in the United States were in fact citizens. So the citizenship clause of the 14th Amendment applies to Chinese. Non-black, non-whites come up again with respect to the 15th Amendment. The 15th Amendment is actually a piece of Jim Crow legislation. This is intentionally structured to provide for racial discrimination because it says the rights of citizens of the United States to vote shall not be denied or abridged by the United States or any state. Why is this Jim Crow legislation? Well, Senator Charles Sumner of Massachusetts, when the 15th Amendment was introduced, proposed that it just prohibit racial discrimination in voting. Why would that make a difference? It would make a difference because it's largely forgotten, except among historians, but for 100 years, non-citizens were allowed to vote in many states. 21 states at one time or another, as an incentive to immigration, allowed non-citizens to vote if they had declared their intention to become citizens of the United States. So the Declaration of Intention was a judicial act, a formal court paper that was required as part of the naturalization process from 1795 to 1952. And it was so pervasively entrenched in the law that it's no longer required for naturalization, but it's still authorized by statute. And if you go to the U.S. Citizenship and Immigration Services website, you can download an application for a declaration of intention. So it's still, there were so many state and federal benefits that were associated with the Declaration of Intent that it's still used over half a century after it's no longer required. And so in order to allow states to permit white non-citizens to vote while denying other non-citizens, the 15th Amendment only applies to citizens. And again, this was something that was debated in Congress. It was discussed in the newspapers at the time. Pro-15th Amendment newspapers editorialized that, don't worry, the 15th Amendment is structured not to allow Chinese to vote. And anti-15th Amendment newspapers said, you vote for the 15th Amendment, you're voting for political control by Chinese. So that's the Idaho Constitution. Persons of Mongolian descent, Indians not taxed, can't vote. The Oregon Constitution says white male citizens over 21, plus those who've declared their intention, can vote in Oregon, but not Negroes, Chinamen, or mulattoes. And of course, after the 15th Amendment, that would apply only to non-citizens. With respect to naturalization, Charles Sumner proposed neutrality with respect to that as well. Also shouted down, they did amend the naturalization statute to add persons of African nativity and descent to free white persons, but they didn't go beyond that. So I think it's completely ahistorical, a complete failure of the originalist method to say that the goal of Congress in this period was to eliminate racial discrimination in state law or federal law. Instead, I think there were anti-racists in Congress and in the states that ratified the Reconstruction Amendments. There were racists, and the balance of power, the votes that were necessary to get the 14th and 15th Amendment across the finish line came from people, Republicans, who were concerned about politics. With the 13th Amendment and slavery being abolished, the 3/5 compromise failed or became obsolete. And so all of the African Americans in the South And there were a significant percentage of the population, a majority in 3 states, as I wrote in an article that I published in the Harvard Civil Rights, Civil Liberties Law Review. All of those people, instead of being counted 3/5, would be counted 5/5. And so it was unacceptable to Republicans to have a consequence of the war be that the South became more powerful in the Congress and, of course, in the Electoral College, because the electors are apportioned in the same way. So that political problem, I think, was necessary to get these laws passed. Color blindness, and I'm not saying that this sort of historical revisionism is necessarily a bad thing. I'm not saying that creating myths and putting, or you might say putting the best possible face on the history is always a bad thing. But if we're talking about what they actually thought they were doing, Congress in the Reconstruction era did not think that they were eliminating the color line from American law at all. So in a number of ways, this form of cooperative federalism resulted in a critical divide being color, white, black, other, not citizenship. So the Declaration of Intent was a part of immigration policy. It was a part of internal migration policy, and it led to, it was the trigger for a variety of state and federal benefits, including the Homestead Act. And this is a predecessor, the Donation Land Act of 1850, which gave benefits not just to citizens, but also to declarants. And it did so because they wanted immigrants to be able to participate, white immigrants, to be able to participate in society the day they landed. Go to court, file a declaration. The General Land Office sent information about the Homestead Act overseas. They translated it into European languages. They were recruiting immigrants, and they're saying, come here from day one. You can vote from day one. We will give you this land. We need whites. And that was facilitated with this. And of course, the states competed for these immigrants too. So as early as the Reconstruction debates, the Chinese question came up: what, if anything, is the United States going to do about Asian immigration? And particularly after redemption, after the 1876 election and the results thereof, Congress turned to this question, and they answered it as a matter of general race policy. And what I mean by that is that they didn't think of what to do with Chinese immigration, what to do with Asian immigration, solely as a question of what to do with Chinese immigration. They thought of it as part of a question of national self-definition. So, in debating the Chinese Exclusion Act, a supporter, Senator John Percival Jones of Nevada, argued, "Does anybody pretend to tell me that it is a blessing to this country that African Americans are here? It's no fault of ours that they're here. It's no fault of theirs. It's the fault of a past generation. But their presence here is a great misfortune to us today, and the question of the adjustment of the relations between the two races, socially and politically, is no nearer a settlement now than it was the day Sumter was fired upon." This is 1882. "What encouragement do we find in our history, in the history of our dealings with the Negro race, or in our dealings with the Indian race, to induce us to permit another race struggle in our midst?" And there were opponents in this all-white male Congress. There were opponents of a race policy, and these opponents quoted lines from the Declaration of Independence and other historical American documents like all men, all persons are created equal. What about that? Why are you trying to keep the Chinese out? All persons are created equal. Senator Grover answered that with the following. The Founding Fathers' conduct towards the Aborigines of this country, whom they found in lawful occupancy here when they came, must be construed as fixing a limit to the meaning of their public declarations upon the rights of man. When they declared that all men were created equal and were endowed by their Creator with the inalienable right of life, liberty, and the pursuit of happiness, they undoubtedly meant all men like themselves, and in like manner joined in the bonds of civil society. And when they dedicated this country to be an asylum for the oppressed of all nations, they undoubtedly meant all nations whence they came, people of character and conditions similar to their own. Senator Miller said, "It is not numbers that are needed, quality is more important than quantity. One complete man, the product of free institutions and high civilization, is worth more to the world than hundreds of barbarians. Upon what other theory can we justify the almost complete extermination of the Indian, the original possessor of all these states? I believe that one such man as Newton or Franklin or Lincoln glorifies the Creator of the world and benefits mankind more than all the Chinese who have lived, struggled, and died on the banks of the Wang Ho." So this was the foundation, or really an important step in a long line of legislation that was designed to regulate the race of the people who came to the United States. I do think the 1790 Act is part of it. There were others, but another major one is the 1862 Coulee Act, which invented the visa. Everybody else could just show up, walk in. But starting in 1862, all people from Asian countries had to be cleared by consuls in Asia. And if a ship showed up full of Asians that didn't have this certificate, they couldn't land. In 1875, something that has dramatic implications for family formation and establishment of communities, the Page Act limits the immigration of women from China, Japan, or any Oriental country. Again, there's this sort of group treatment. How many other Oriental countries had people here that could be judged? Not too many, but nevertheless, better safe than sorry. We'll just pass a law that applies to all Oriental countries, says Congress in 1875. And then as different Asian national groups start to immigrate in numbers, they are, one way or another, excluded. The perfection of the laws comes in 1924, where Congress says that people who aren't allowed to naturalize as citizens are also not allowed to immigrate as immigrants. So aliens ineligible to citizenship are excluded. And in 1923, we have a decision that says an Asian Indian, what the court called a Hindu, was not a white person and therefore could not naturalize under the principle established in 1790. And the court basically says that Taney's language in Tao was right, that the United States was founded by Europeans, for Europeans, bone of their bone and flesh of their flesh. And that's who was invited to come to the United States and become a citizen, including the Slavs and dark-eyed, swarthy people of Alpine and Mediterranean stock. So they're saying that Europeans as a group are invited in. So that's the situation around the turn of the 20th century. We have what I would regard as a multiracial Jim Crow system. There are certain things that apply across the board. Miscegenation laws apply to different racial groups. Restrictive covenants apply to different racial groups. School segregation applies to different racial groups. All of these racial groups in one way or another are disenfranchised. And then we have specific things. African Americans, of course, don't have large tribal reservations to be expropriated. Africans and Native American people have a different immigration situation than Asians. And so there are separate things for each group, but I think it's part of a larger racial policy. This is a passage from a unanimous US Supreme Court decision saying that Japanese are not allowed to naturalize. And they say that the racial restriction on naturalization is fundamental. It's pervasive. And we're going to have to read that as a policy as well as specific language from specific text. There's a principle here. And I think this language accurately captures not only the immigration and citizenship question of Asians, but also the legal regime as a whole as it applied to African Americans and Indians. This is a editorial from an African American newspaper in Minneapolis that criticized the US Supreme Court's decision in a case called Fong Yuting versus United States, which basically held that Chinese or any non-whites could be deported at any time because of their race. I think it's a logical impossibility to say that white people could be deported because of their race. We have a policy, how could there be a policy of getting rid of white people from the United States? It doesn't make any sense. But there could be a policy of getting rid of other racial groups. And the Supreme Court said that that was a permissible policy for Congress if they wanted to adopt it. And the editors of the appeal said, Chief Justice Taney said that African Americans have no rights the white man is bound to respect, but isn't that true of all non-white racial groups? And I think they have a point. So, as a sort of example of the pervasiveness of the systematic nature of race law in the United States, I want to talk about Utah House Joint Memorial Number 1 from 1921. This was a document that the Utah legislature sent to Congress in support of the Asian exclusion laws. They wanted them toughened up. Now, this is 1921. In the 1920 census, there were 449,000 people in Utah, of whom 441,000 were white. Asians were less than 1% of the population. They were the largest single non-white group at the time, but less than 1% of the population. So there can't have been a big Asian problem in Utah. But these policies were about vigilance. They were about prevention of problems from arising. And I don't mention Utah, and I have a few more Utah things to mention, but I don't mention them because Utah was a particularly racist state. That's not the case. Utah was less racist, measured by Jim Crow laws, than a lot of the other Western states. But even Utah got involved, and they said, okay, Congress, the fact is we have Asian immigration. It creates problems. Asians can never assimilate. They can never be part of the society. And we need your help to make sure that this problem doesn't materialize. So these are the background facts. And the specifics that they wanted are, we want you to promise, Congress, that you will not, by treaty or by statute, allow Asians to naturalize. We want you to toughen up the restrictions on Asian immigration, which by this time were very strict. Severely limited. And we don't want you to do anything by treaty or by statute that will change the right of states to prohibit Asians from owning land. So we're going to keep them out. That's insufficient to solve the problem. We also don't want the few who are able to get here to be able to participate in the economy to the same degree. This set of classifications that the Utah legislature wanted to exploit, we want to be able to treat aliens who can naturalize differently from aliens who can't naturalize, was blessed by the US Supreme Court. The US Supreme Court said, Congress, through the 1790 law, allows some immigrants to naturalize and some not. That can't just be nonsense. It can't just be racism. It just can't be protectionism, that some people, we're going to favor some people at the expense of others for no good reason. There has to be a legitimate reason. We're not going to get into why, but there has to be a legitimate reason, and the fact that Congress draws this line means that the states can too. Another example of the vigilance was the miscegenation law. And in 1937, I want to say, with regard to Utah House Joint Memorial Number 1, it passed 12-4 in the Senate and 43-1 in the House, which is actually less, there's a greater division of opinion there than there would have been in a lot of other states. And I want to mention that the one person in the House was a lawyer named John L. Sevey Jr., who was the son of a Utah pioneer, later became a judge, and he was a graduate of this law school. And it must have taken some courage to have all your colleagues vote one way, and you're like, well, I'm just gonna vote the other way. But that's John L. Sevey Jr., who stood on his opinion. Another example of the vigilance at issue here came in this 1937 opinion of the Utah Attorney General, who was asked to decide whether a Filipino, a Malay, could marry a white person. And he protected his record by saying, I personally am opposed to interracial marriage. But as I look at the law, I don't think our law prohibits a marriage. It doesn't cover Malays. Because when we look at the scientists who they don't mention Malays, and they're not one of the races that's listed in our statute. So I think if you look at Blumenbach, a marriage between a white person and a Malay isn't prohibited. And again, not that many Filipinos in Utah at the time, but the legislature at the next session passed a law that added Malays to Section 6. Also prohibited. So that's the structure of my argument, that the discrimination is systematic, that it's pervasive. I have a couple of arguments that are more anecdotal. And there are specific forms of discrimination against Asians that are specific, but I think with enough of them, they add up to the idea that it's going to be hard to find a place, a corner, an industry, a time where the kind of vigilance that resulted in this law didn't cover everybody and everything. That's my argument. Everybody and everything. And so one example is what I wrote about in the War Against Chinese Restaurants, which was a decades-long effort by labor unions to eliminate Chinese restaurants from the United States. This was their avowed goal. Cooks and Waiters Union, North, South, East, and West. They used a variety of techniques, including boycotts In a number of states, they persuaded licensing authorities not to issue licenses to Chinese restaurants. In Chicago, they got a zoning ordinance passed that prohibited Chinese restaurants. The movement got a big bump in 1909 when a young white missionary, Elsie Siegel, granddaughter of a Union general, was murdered by her boyfriend, who was a Chinese restaurant worker. And there was a moral panic about white women going to Chinese restaurants. Beer and noodles, reports the Madera, California Mercury in 1912. Beer and noodles in Chinese joints have caused the downfall of countless American girls. Something you don't hear very much today. But this was a real view in the first 20 years of the 20th century. One of the things that happened is that Leon Ling, the boyfriend who committed the murder, was never caught. Hundreds of Chinese, Japanese, Korean, Mexican men of every age and description were arrested all around the country. So this is the Salt Lake Evening Telegram reporting that Leon Ling was arrested at the same time in Illinois and in London. And it became a joke. The Deseret Evening News here quipped in July 1909, "It's a long time since Leon Ling was last arrested." The Salt Lake Herald said, "Leon Ling has been located in Austria. He'll be due in Siberia next week." But the punchline of this was that the American Federation of Labor proposed a law that would prohibit white women from working in Chinese restaurants or Japanese restaurants, just for good measure, because it's morally and economically a serious menace to society. And these laws were introduced in a number of places, and more would have passed. The Massachusetts Supreme Judicial Court held that it would be unconstitutional, and so even though one house had passed it, they issued a declaratory judgment against it. It passed one house in Montana and would have been enacted into law, but the Secretary of State called and said, "This will cause international problems for us, so don't do it." But as evidence of the pervasiveness of it, this played out in Ogden, where one of the techniques that was used to deal with Chinese restaurants was to prohibit booths in Chinese restaurants. And these booths were like little rooms. It wasn't a booth like in a steakhouse, like a couch. It was a little room. And Ogden passed a booth ordinance upheld by the Utah Supreme Court. The ordinance is still on the books in Ogden. And Chinese people and their allies in the Ogden newspapers said, "Hey, you are enforcing this only against the Chinese restaurants. Why don't you make white people obey the law?" And so I don't know if it was a discriminatorily enforced law or not. There was debate about it. But I do know that the Cooks and Waiters Union was active in Ogden, that there had been boycotts of Chinese restaurants before. In any event, the Public Health Service published a model ordinance that proposed that people should prohibit booths. We're running long, but there's another body of law that I want to talk about quickly, and that is after having done the piece on exclusion of Chinese restaurants, or efforts to exclude Chinese restaurants, I stumbled across, with my co-author, my brother Sam Chu Chin, another body of law which was designed to exclude Asians from serving as crews on US flag vessels and from participating in the fishing industry. And there's a significant body of law in Alaska, in Hawaii, and other coastal areas, and federal law, still on the books, that imposed these citizenship requirements, also language requirements, which were pursued by the unions and designed to reserve jobs to whites. Of course, many of the people in the Sailors Union were themselves naturalized immigrants from European countries. And once again, Utah had a hand in this. And so I'll try and be quick with the conclusion. And so before World War II, there was a sense that immigration should be reserved to whites, land should be used by whites, economic opportunity was for whites. All of those things happened. These were not policies that failed, these were policies that succeed. Now, if you accept my argument that law was pervasive in this period of time, it's obvious that things have changed. Today, it's not possible to say that there's discrimination and racism today, but it's not possible to say that it has the same scope, intensity, and effect that it did before World War II. Between the mid-40s and the 1960s, there was tremendous change. And it was sufficiently dramatic and complicated that I can only speak about it in generalities, but I will give you a couple of those generalities. One is that an important feature of the change was war. We had big movement in the 1950s and the 1960s when we were in hot wars in Korea and Vietnam. We had a Cold War with the USSR. Scholars Derek Bell and Mary Duziak said that desegregation was a Cold War imperative with regard to all of these non-white racial groups because in the geopolitical struggle for survival, racism was embarrassing. With regard to the elimination of anti-Asian immigration policy in 1965, there are some scholars who claim it was a fig leaf, that the elimination of the bars was designed to maintain the same traditional flow of immigrants from Europe, but in a less obvious and less offensive way. My reading of the legislative history is to the contrary. I do believe that the legislators who passed the Voting Rights Act, who passed the Civil Rights Act, and who passed the Immigration and Nationality Act amendments of 1965, that the balance of power there, unlike in the Reconstruction period, was in the hands of actual anti-racists who were trying to eliminate racism from American law. But this was an elite change, an elite vote. Because if you look at public opinion polling at the time in 1965, the bulk of the American people were happy to leave the immigration system as it was then. Another key characteristic, and I'll close with this, is that change was piecemeal and incremental. So, for example, Utah repealed its anti-Japanese land law in 1947. The prohibition against miscegenation was eliminated nationwide in 1967 with the US Supreme Court decision in Loving versus Virginia. That decision had no impact on Utah because Utah had already repealed its miscegenation law in 1963. So there were steps that happened in state courts, in federal courts, here and there, different areas throughout the 40s, the 50s, and the 60s. But there was never a moment where there was a clear legal decision or policy decision that race discrimination is wrong, we're going to stop doing it, and we're going to look at the various aspects of society and figure out what parts of it have this historical racism in it, and it has to be changed. Instead, there was massive resistance to Brown. There was resistance to the Civil Rights Act and Voting Rights Act. And so racism, the legal structure of racism faded away, and I believe it's radically changed since before World War II. But there was never a moment where there was a systematic effort to get rid of it, root and branch. Okay, I'll stop. Thanks.
Thank you. Thank you very much. I will be moderating the Q&A. We have questions coming in over the Slido, which I did not explain. And we also have mics that we can walk around the room for people in the room who have questions. I would like to, because I have the microphone, start with the first question and a thank you. Thank you so much. It was really wonderful to see the Utah history of this. I had not seen that presented before, and it was wonderful to have that for this audience. You mentioned that, I guess I want to ask you about how there isn't an anti-racist, or there hasn't been a move to end race discrimination on the court. When we have, you cited the Fisher case. Since Brown versus Board, we've seen the kinds of plaintiffs who are bringing anti-discrimination litigation no longer, since Korematsu, have they been primarily people of color. It's been white Americans who are arguing that racism and racial discrimination is wrong. And you see that articulated in how, say, maybe Justice Roberts writes in Seattle schools, right? So there is a discourse around race discrimination being wrong and color blindness being right. I wonder if you could speak to that, or if you just disagree with that characterization.
No, I mean, I think the Supreme Court's view is driven by a lack of a full appreciation for the scope of the discrimination that existed in American law. And they have these sort of casual, historical observations that certainly Justice Scalia, but before and after, I don't think. So somebody like Nathan Glazer, a scholar, but somebody whose criticism certainly has made it into the legal arena, they say, well, you ask an Italian or an Irish immigrant to sacrifice themselves for a black person? Why? They came over and they had nothing and they didn't get anything, and they had to struggle to survive. And there's some truth to that, to be sure. But the idea that nobody gave them anything, well, the Homestead Act was for them. The ability to become a professional because they could file a declaration of intent. There were a lot of benefits. The whole of when affirmative action was white stuff. As far as I know, at least after the Civil War, there was no effort to disenfranchise Irish people. As far as I know, and I'm happy to be corrected on any of this, there was no restrictive covenant that limited the ability of Irish people to own a home. There were no separate schools for Irish. And now what there was interethnic competition. Who is going to control the New York Police Department? Is it going to be Irish? Is it going to be Italian? The Jews Jewish immigrants have a hand in this, but it wasn't going to be Asians and it wasn't going to be blacks, and so I don't question discrimination, but what I'm talking about is different from discrimination, and it is discrimination, but not being able to be a citizen and being categorically excluded from broad aspects of society is different from the kind of interethnic competition that exists today. It's perfect. I can imagine, just as I can imagine, there might be a law firm partner who says, I'm happy to interview people from where I went to law school as opposed to where somebody else went to law school, and that's discrimination. That's not hiring somebody based purely on merit, but it doesn't systematically exclude people from the opportunity to participate in society the way inferior segregated schools do, say. And so I think that people like Justice Powell and Bakke and people like Justice Scalia in a lot of affirmative action cases say, look, everybody was discriminated against. But I think we can draw a line between For example, not being allowed to become a citizen and certain other things, not being allowed to own property and certain other things.
Thank you. If there are questions from the room, I'll come bring another mic.
Thank you. You know, my father immigrated to Utah about 1910, and I've always been under the impression that one of the reasons he came here was that he could own land, because he was a farmer, and not California because there were alien land laws. Can you help me or clarify to me? You mentioned that there's an alien land law in Utah until 1940 something.
Yes.
Was it enforced?
So again, the answer to that question is that Utah was not as hostile to immigrants or as eager to recruit white immigrants generally as some other states. And so the truth of the matter is that Utah did not get its alien land law until 1943. So it was a war measure. And up until then, it said that the states should have the right to exclude aliens from owning land, but Utah did. You're absolutely right. Utah did not exercise that right, even though in this memorial they indicated that it was important. And so I don't understand the political background of that fully, and it may be that that the political consensus was there to send a memorial rather than pass an actual operative law, or it may be that there were few enough Asians in Utah that even though they wanted to be able to do more if necessary, they didn't feel the need to do it at that time. But you're right. In Utah, up until 1943, Asians could own land.
Professor Francis?
I'd like to hear you talk more about property, actually, specifically because I know there were racial covenants that excluded Asians in the same way they excluded blacks. I know there were land expropriations during the Japanese Exclusion Acts, for example. And one of the major reparations arguments that's made today has to do with the theft of land and the inability to build wealth that's part of structural racism. And I didn't hear you, I wasn't quite sure what you said a minute ago about land. I mean, obviously it was different in different areas of the country, like Utah. I mean, Utah's had a history of welcoming immigrants in a lot of ways that some areas haven't. But
So
what about the pervasive ongoing impact of these laws, or has that sort of dissipated?
And might you speak about your project to remove racially restrictive covenants and Jim Crow law elements if it works with this?
It's really just a question to see.
So in 1790, a lot of states had general alien land laws. No alien, whether you're eligible for naturalization or not, whether you've declared your intention or not, no alien can own land. As the United States became more and more self-conceptualized as a immigrant destination, a lot of states changed that, and some states, like New York, said anyone can own land, period. Resident alien, non-resident alien, race irrelevant. But it's complicated, but really probably the true operational beginning of the restriction on land ownership comes in California in 1913, where an initiative is passed that says that aliens ineligible to citizenship, which everybody knew what that meant, can't own land. And this initiative was picked up in other states. Washington, Oregon, Nevada, New Mexico, ultimately 15 states, including eastern states, Delaware, Florida. And because of the Civil Rights Act of 1866, you couldn't prohibit a citizen from owning land. Now, there were other games that could be played with regard to citizens. And that's one of the things about land ownership that I'll get to in a second. But these laws either restricted land ownership to declarants or citizens, or to people who were eligible to become citizens or citizens. And they were intended to limit the right of Asians to own land, both as an immigration policy, because the primary mover behind the 1913 law was U.S. Webb, the Attorney General of California, and he said that they won't come and stay among us if they can't work the land. Agriculture is very important then. And it was also thought to be a matter of national security. And so when the U.S. Supreme Court upheld these laws, they said, hey, it's possible that if we do allow foreigners to own land, that they'll own every square inch of the state. That would be a problem, okay? It seems unlikely to me, but anything's possible, isn't it? And so there were a number of escheats in California where the Attorney General came in and took the land back. There was all kinds of other ancillary litigation where people said, I don't want to perform because this person, can't legally hold the land. So it did affect the rights of non-whites, and I have cases that involve Koreans, Asian Indians, Chinese, Japanese. It was a problem for them. I will say that in 1951 and 1953, the California legislature voluntarily, and this is part of this 1940s to 1960s sea change that I talked about. In 1951 and 1953, the California legislature decided to pay reparations. Every person, because these are judicial actions, escheat is a judicial action, they were able to identify every person who'd had their land taken from them, or sometimes they would pay a settlement, which is weird. If a Japanese person isn't allowed to own land, why is the Attorney General allowing them to keep the land if they pay $25,000? But they did. And they gave all the money back with interest, at least to people who filed claims. And to me, at the end of the day, I don't think it's justified to pay. I do think it's justified to pay reparations to these people, but I don't think it's justified to pay reparations to some people who've lost assets and not others. And I think we have to think about other people who might be in the same situation. When you talk about African Americans, to me, what's interesting about that is the multi-layered nature of the racial regulation. So we have private contracts, restrictive covenants, layered on top of that, ordinances that restrict neighborhoods by race that were held invalid in Buchanan versus Worley, but there were cases for a decade or two after that that still tested them. And so just because a law is unconstitutional doesn't mean it doesn't have effects. People know well now because of The Color of Law, Richard Rothstein's book about government finance and government loans. And so the federal government participated in segregation. And then another sort of semi-private, semi-public system of regulation, the realtors, who had an ethical rule of not selling a home to someone whose characteristics were incongruous with the neighborhood. And the trick there is that a lot of the licensing requirements or the licensing rules You can lose your license as a real estate broker or real estate agent if you're convicted of a crime of moral turpitude or this or that or the other thing, or if you violate a regulation of the Realty Board. And so these regulatory requirements or these private professional guides were written into law. And so there are all these layers of limitation of the right to own property that I think were very effective. And I think it's hard to account for the consequences in the case of any specific person today, but I think if we look at it, it has to be regarded as systematic and a systematic allocator of wealth.
Thank you. I'm going to take the questions from the Slido, and I believe we have to end it, or we're supposed to end at 7:30, but I'll read them all to you and you can decide. One question is, you talked about laws that limit voting rights. Were there barriers to minorities running for public office? I guess this is imagining that you can't vote if you're Asian, but maybe you could run for office and people could vote you in. The other is agreeing with you as to your point of negative views of Chinese restaurants and submitting that continues to persist today. And then finally, you've spoken about originalism. This question asks, what are your thoughts on the works of reform originalists who have recently tried to construe the Reconstruction Amendments to reach a variety of racially progressive outcomes on nominally originalist grounds? And then I'll share a final comment that's just come in. Comment only. My family is Japanese. I grew up on a farm that my father and brothers purchased. Since my grandfather could not purchase the land, they leased the farm land prior to being able to purchase it. So people find ways to get ahead. So any of those comments, questions you care to comment on in your last moments? Thank you.
So for the most part, the laws in most states that I'm familiar with said that to run for office, you have to be an elector. And so there was an overlap between being able to vote and being able to run for office. And I'm not familiar with too many situations where those civil statuses were separated, except perhaps in the case of declarants. During the era when declarants could vote, they couldn't necessarily run for office or hold office, although in some cases they could, and in some cases they could serve on juries. And there, the evasion of the alien land law and other laws is interesting. Throughout the exclusion period, it's not as though Asians didn't come. There were certain categories that were allowed to come: scholars, teachers, merchants in particular, which is interesting. Merchants is easily explained. The commerce with Asia then as now was economically important, and there were people who treated it as very significant. And so it's not surprising that throughout this whole period, merchants and their families were allowed to come. And you see Supreme Court, I think it's 1923, 1927 maybe, anyway, somewhere in the 20s where within 1 year, there's a decision that says, a US citizen is not allowed to bring his Asian wife into the US because Asian women are excluded and you only get to come if you're eligible to citizenship. However, a Chinese merchant is allowed to bring his spouse with him because that's permitted by the treaty. And I think the thumb on the scale was, we're not going to interfere with, we the Supreme Court are not going to interfere with commerce unless Congress directly tells us to. But if we're just talking about race policy, that we can understand. But there were also, so there were certain legal ways to get to the United States. And one of them was as the child of a US citizen. And there were frequent proposals to eliminate derivative citizenship for non-white US citizens. That if you're a white US citizen and you have a child overseas, they're a citizen, but if you're Black, Indian, Asian, you have a child overseas, they're not a citizen. Congress was never willing to go that far. That was a line that they drew, which, okay, they have to get credit for that. But it did mean that there was an opportunity for for falsely documented immigration. And people came to the United States claiming to be the children of U.S. citizens with the support of that U.S. citizen when they weren't really the child of that U.S. citizen. I'm talking about an American-born Chinese person who went back and forth to China and registered, people would register, men would register a birth every year just in case. And, what do we think about that? What do we think about people who found a way to own land even though the law prohibited them from doing it because of their race? And, I'm a law professor and I don't condone breaking the law, but I have to be frank that my answer is that, that we get the answer from Martin Luther King's letter from Birmingham jail. One has not only a legal but a moral responsibility to obey just laws. Conversely, one has a moral responsibility to disobey unjust laws. I would agree with St. Augustine that an unjust law is no law at all. And so I do not think that there's a moral obligation to obey segregation laws.
Thank you. Thank you. On that note, everyone, let's please thank Professor Chen for his lecture.
Here.
I thank you for being here. And on behalf of the University of Utah S.J. Quinney College of Law, we have a small token for you. Thank you. Thank you to the audience at home that I guess just got cut off. Thank you to the audience in the room. Thank you, Dean Cronk-Warner. Thank you, Professor Francis, member of my faculty and colleague, for being here. And thank you all. We look forward to continuing conversations with you and hope you'll come back. Thanks,
Professor George.